Hello and welcome to today's webinar. This is with the Fisher Phillips Ag Attorneys on the current state of employment law and COVID, hosted by the Georgia Fruit and Vegetable Growers Association and presented by Fisher Phillips attorneys Marty Heller and Joshua View. This is actually the culmination of the Ag Labor Insights podcast series created by Fisher Phillips for GFVGA with our Southeastern fresh produce industry in mind. So these podcasts can be easily accessed on our Georgia Fruit and Vegetable Growers Association website, www.gfvga.org. Today's webinar gives an overview of our past, our present, and our future insights, and what our industry has seen, is experiencing, and what we might expect in the short, near future. Then we're going to open it up for questions and answers with Marty and Josh. And that's always fun to be able to try to stump the ag attorneys. So I'm Beth Olson, Director of Education and Food Safety with the Georgia Fruit and Vegetable Growers Association, and I'll be moderating today's webinar. So before we get started, just a few housekeeping items. So please note that GFVGA's antitrust rules are in effect for this webinar. So there will not be any exchange of information regarding matters pertaining to price, refusals to deal, market division, tying relationships, or other topics which might infringe on our antitrust regulations. This webinar is being recorded, so all registered attendees will receive an email with a link to the recording in just a few days. It will also be available on the GFVGA YouTube channel, so be sure to type in the full name Georgia Fruit and Vegetable Growers Association in that YouTube search bar. So all of you should be muted and come in muted to the webinar, but we do ask that you would self-mute on your phone, computer, or device. We are going to be taking questions throughout the entire webinar, so feel free to type those into the chat box. We'll be keeping an eye on those. And then at the end of the webinar, we'll be sure to answer everything that comes in. So with these housekeeping items behind us, I'd like to introduce Chris Butts, the Executive Vice President of the Georgia Fruit and Vegetable Growers Association, who is going to introduce today's presenters.
Hey, thanks, Beth. And thank you to Marty and Josh for being here with us. We are very proud of the relationship we have with Fisher Phillips, and we're very proud to bring you this programming. Ag labor is consistently listed by our members as the issue that keeps you up at night. And our job is to bring you kind of consolidated programming. You've got information coming at you from so many different sources. If we can bring you a short, hard-hitting program at lunch that can get you up to date on all the myriad of changes that we see in ag labor regulations, then we feel like that's a good use of our time and your time. So without further ado, you don't want to hear me speak or Beth. We're here to hear Marty and Josh speak. So Marty Heller is a partner at Fisher Phillips, where he focuses much of his attention on wage and hour compliance. Marty is joined by Josh View, also a partner at Fisher Phillips, where he focuses his attention on labor relations as well as wage and hour compliance. So without further ado, we'll turn it over to them and get started. Thanks.
Perfect. Thanks, Chris. Josh and I are here today to talk to you a little bit about kind of the culmination of, as Beth said, the number of podcasts we've been putting together over the last few months. And boy, talk about the changes, kind of crazy, where we were a year ago today to where we are now, especially with the anticipated release and then the release of the mandatory vaccine or test rules. And hopefully you got the chance to join one of the many webinars we did for Georgia Fruit and Vegetable Growers on that topic. I feel like, Beth, it changed every month and we kept updating everyone along the way. And boy, some of the things we're going to talk about today are really fascinating when you consider where we were as to where we are now, and just the huge jumps that administration has taken in their perspective and rules on COVID and on testing. So I'm going to cover a bit of that, and then Josh will have some topics for you on absconding and what we've been seeing lately, and just a few other quick hitting topics, with the goal being that we'll get through our content and make sure we leave plenty of time for questions, because I know we get a lot of them pretty frequently. But let's go ahead and get started. So, from my perspective, I think one of the most interesting things, if you saw it, the 60 Minutes interview with President Biden over the weekend, I thought was fascinating, with the official statement, at least from the president's perspective, that the pandemic is over, and not that COVID is gone. Of course, we know COVID isn't gone, but the administration's perspective that the pandemic is over. It's a new position to be taking, and we're going to talk about a few things that happened over the last 2 or 3 months that really led to what I think the culmination was, seeing that statement in an interview that, of course, aired on Sunday. But I think it's really fascinating to think about what that means for a lot of the EEO perspective, the EEO laws and the labor and employment laws we've been dealing with. Because if there's not a pandemic, so much of what we've been advising and permitted as employers to do sort of disappears. So we've been seeing the signs that this type of statement was going to be coming, whether it's from the EEOC or from the CDC, both of which issued new guidance and on their websites over the last 2 months, both in July and in August. So really interesting, kind of projecting of what led to this, but it's still going to have significant impact. So you're still going to have people getting sick. You're still going to have, people needing to miss work, and you're still going to have a lot of people requesting accommodations as a result of COVID. So I think covering those issues first makes sense, just because it's the newest guidance that we've received on COVID issues. So going all the way back, and this is back to, I guess, June of 2020, when we first got the EEOC's guidance released on COVID. From that point forward, so, 2+ years, we've been operating under what's called the direct threat universe. I guess what I call a direct threat universe, which is the EEOC told us from the beginning of that time frame forward, COVID was a direct threat. And that's a legal term, which means if you had COVID or if you were exposed to COVID, you were a direct threat to yourself or others in the workplace under the ADA, which meant that employers had a lot of freedom to engage in testing, screening, things like that. So 2 months ago, EEOC released this new guidance. It was not highly publicized, which I think is interesting. The question is whether they're trying to catch employers in making mistakes based on relying upon prior guidance, when the new guidance it's kind of hidden. You had to go through the document and find which questions were changed. But number one thing they changed was to say that this idea of testing as a screening tool, and this is of any employee, the idea that testing on a regular basis is permissible just as a matter of right for an employer, went away. And when you talk about where we were, just, oh goodness, it's, exactly a year ago, September, October timeframe when OSHA released its rules, where it was mandated testing, moving to now you can't test without some showing. And so the first question we got a lot of was, okay, well, if we want to do testing, someone's been exposed and we want them to get tested, something has occurred and we want testing to be done as a screening method. What is required? And so the EEOC gave us these factors. Good luck determining which one is the most important and least important, because as lawyers, Josh and I have no idea. All we know is this is what the EEOC has told us they're looking at. But they want you to take into consideration the current transmission level of COVID where you are, the transmissibility of the current variant. So what is the current COVID variant going around, and what, is it highly transmissible, highly contagious, or is it a much lower transmissibility level? What type of testing are you proposing to use, and how accurate is it? What is that particular employee's vaccination status? I'm not sure that factor really makes sense as to whether you should test or not anymore, but it's part of what was provided in the guidance. What are the work conditions for the impacted employees? And for our ag community, this is the big one, because the question is often going to be, are we talking about H2A workers? Are we talking about workers in the field who are living together? Are we talking about employees in an office who are spread out? That'll have an impact on whether screening testing is appropriate. And then what would an impact of a positive case be on operations? I will tell you, and Josh, I'm curious on your perspective on this, but from my perspective, the number of calls I've gotten on the impact of positive case on operations this year is way down. And what I'm seeing generally is a lot of people viewing this, as we saw it going, kind of like, look, it's the flu, it's a bad cold, but it's not shutting down operations this year. Are you seeing the same thing?
Yeah, definitely. And much, I think people, as we've learned more about the virus, and then also as the variants have gotten less severe, people are much more comfortable dealing with this as, for lack of a better term, a normal illness. And so there's not as much of a, we need to shut everything down type reaction to it. Because we know, it's you stay home, if you're displaying symptoms and all that. So, I think for a while, Marty and I were probably getting half a dozen calls a day on how to deal with this. And I think employers and in line with the country in general have gotten more comfortable in dealing with that.
Exactly. So a couple other things from the EEOC guidance I think are important to note. So they still permit testing for new hires, but it's a medical test from the perspective of the EEOC. And so what that means is it's something that is done post-offer pre-hire. So when you think about all other medical inquiries, if you were to do, some sort of testing of employees for their ability levels on physical fitness, for example, that would have to be done post-offer pre-hire. And this is just like that. Now, what's interesting about this guidance is we were previously provided with guidance that employers could, if you tested positive, employers could withdraw the offer. And I use the word firing in this slide, but what we really mean is withdrawing the offer because they were never actually placed in the position. EEOC has pushed real hard on the withdrawals of offers for people who test positive post-offer pre-hire. And what they're focusing on is another list of factors that essentially boils down to why can't you hire them in a week or two when they'd be safe to be working instead of hiring them now. And so from my perspective, and I haven't had anybody really push on this particular analysis yet. Most of my clients have said, look, we'll just push back the start date a week or two, especially with the potential of only needing to be quarantined for 5 days. But if you need that employee now, and you really need them now, it's important to be able to show that you've got somebody else waiting in the wings that's going to be there that can immediately take that position and establish why that person needs to be there right away. So you really need to have a job-based justification for deciding to withdraw the offer. It's not something that we can just lean back and say, well, the EEOC guidance says it, because it doesn't say that anymore. So I think that is an important change to remember. And then last in the guidance is a continued perspective the EEOC has had, which is antibody tests are not the same as COVID tests. The EEOC does not recognize antibody tests as valid for work requirements, and so employers are not permitted to require them. And I still see this pretty regularly as a mistake that's made by a lot of our clients, is they use the antibody tests the same as a COVID test. So not surprisingly, the EEOC issued their guidance late June, July. And we saw within, I don't know, 2 or 3 weeks later, in August, we saw CDC update their guidance on this. And so what we learned from the CDC is they basically followed suit with the EEOC. And when I talked about projecting the types of changes we anticipated seeing that we're now hearing come out of the administration, the CDC guidance was the most clear example of that. One thing I want everyone to remember, though, is that the CDC and OSHA are not the same. Now, OSHA throughout the period of COVID, throughout the pandemic, has been relying on CDC's guidance and their guidelines, but they don't have to. And so we could see the odd situation where employers are following CDC guidance and OSHA say, no, that's not sufficient, that's not good enough. We have not seen that yet, and I hope we don't get in that situation because that's a nightmare. But it's entirely possible that may be a situation that arises. So what we are seeing right now with the CDC guidance is, of course, social distancing is something that the CDC has been really pushing on since the beginning of the pandemic, and they have finally let go of that. It doesn't mean that social distancing isn't still recommended, but it means that it's been given a lot less importance in the most recent guidance. Same thing with screening of healthy employees. So where we were previously asking questions every morning, answering questionnaires, have you been near anyone that has COVID? Have you had a fever? All these questions that we were asking before, CDC de-emphasized that. And really interesting in these, in the new guidance was eliminating contact tracing except in very unusual circumstances. So the investigation into who have you been near, how many people were there, how long were you in close contact with them, really, unless your CDC basically said, unless you're in a senior living facility, it's de-emphasized. And it doesn't mean you couldn't do it if you wanted to, but it means it's no longer presumed it's necessary. Employees who are positive remain home for 5 days and then return with a mask as long as they are symptom-free or at least substantial symptoms. What I like to say is fever-free and don't feel sick. Keep it simple, right? And then employees who have had some limited exposure, there's not even a quarantine period anymore. They're expected to work with 10 days wearing a mask and test it 5 days to ensure they're not sick. But if they're not showing symptoms, there's not even that quarantine period anymore in the most recent guidance. So it's a pretty dramatic change to the previous guidance, and something that really does give you a lot more freedom in how you want to manage these types of situations. Before I jump to OSHA, I just want to make sure, Josh, do you have any other thoughts you want to add to the EEOC and CDC guidance changes?
No, Marty, I think you covered it.
So as if you heard the podcast from Travis Vance that we did for Georgia fruit and vegetable growers on OSHA's heat standard, we've been hearing about it for a while now. I will say we continue to await a rule. So a lot of this is just speculation based on what Travis knows, what we hear, and what we've seen from other states that already have heat exposure rules, heat standard rules in place. So currently, we remain at the status quo. There is not a federal heat standard. It does not exist. There's not a regulation on it. What do we know, though? We know that OSHA has already published internally that they are working on the notice of proposed rulemaking. So that means that a regulation has been written in some shape or form and is currently in review at OSHA. So it hasn't been published. So most of what we're going to talk about is what we anticipate or expect. A lot of this is what we anticipate or expect and have been expecting. What's scary for our Southeastern growers, and especially for those in Georgia, is that if it really does cover heat index at 80 degrees, which is not 80 degrees on the dot, but of course, what the heat index sits at, I mean, that's a lot of the year. We're talking about, for Georgia growers, especially South Georgia growers, that being a significant portion of the year that's impacted by the heat standard. And what we may see, and this is really impactful for those who have packing sheds is in other indoor areas that get hot that are not necessarily covered by efficient air conditioning, if at all, is that it may be covering indoors and outdoors. So it's going to affect a lot of our packing community. It's also going to affect a lot of people who have manufacturing facilities. So what we expect the requirements to be are, some of this is easy. Water, right? Got to be water out there. Rest breaks and shade. Those are easy ones. That's what I call the low-hanging fruit. The training of managers and employees on the heat requirements and how to spot heat stress and heat illness. One of the more important things is that you would train not just managers, but employees as well, because fellow employees on, for example, a picking line are going to need to know together how to spot this if one of their coworkers is suffering from heat stress or heat illness. A scary component that may be included, that is included, I believe is included in the California plan, is acclimation requirements with ramp up periods. So that would mean with your H2A and domestic workers that they can't immediately be put to full day's work, but need to acclimate to outdoor hours based on the number of days that are over the heat index of 80. So there's going to be huge pushback to something like that. But that is potentially going to be included. Of course, a heat illness prevention plan and first aid training, medical monitoring for anybody who either has a history of heat stress or heat sickness, or has experienced it since they've been working with you, and then record keeping requirements such as recording any heat illness in your 300 or in your logs. So we don't have currently these regulations. Despite not having regulations, OSHA has already announced a national emphasis plan for the heat stand or for heat illness. And so it means that OSHA is going out there and doing these investigations and reviews based upon the general duty clause. And for those of you that don't know, the general duty clause is OSHA's way to cite anyone for just about anything. It is their default. If they don't have a rule in place, they will rely on the general duty clause, which says you failed to maintain a safe workplace. They are already out there doing these investigations on hot days. If you haven't seen them, you will see them. They're showing up and making sure there's water, there's shade, and there's rest. So take the low-hanging fruit that you can and implement those changes now. If you don't have water on every line and readily available, if you don't have some sort of break schedules, especially on very hot days where they can take a break and sit in shade, focus on doing that now. I can't tell you what is sufficient or insufficient because there's not an official rule on it. But what I can tell you is, focus on being reasonable. You don't want injuries in your workplace. Your employees don't want injuries in the workplace. And especially on days that are especially hot, we want to be very focused on making sure that OSHA isn't the one that shows up and looks at the line and says, this is unacceptable, because you will be hit with those citations. Make sure any injuries are logged. And then last on this, expect the changes in 2023. That's, I think, a pretty reasonable expectation, is it will be probably spring to early summer of 2023. But that doesn't mean that the changes are implemented then. That's when I expect to see them published. I think that the objections to this rule are going to be very similar to the objections we saw to the COVID rule, in that I think we're going to see a massive amount of lawsuits filed saying they don't have authority to do this. And I think moving from there will be interesting to see what the challenges actually result in. All right, I'm going to hand it over to Josh on some other hot stories.
Yeah, and one of the real hot stories this year has been the number of absconding H2A guest workers that growers in Georgia and elsewhere have been experiencing. And I actually did one of the podcast episodes on this very topic. And then also what I'll talk about in a few minutes is kind of the overlap between doing what you can to try and discourage workers from absconding from employment and potentially facing allegations of trafficking and those type issues. But no doubt, I mean, that the problem with absconding workers has been exacerbated by the number of jobs available. And what we're seeing is not just H-2A workers absconding for other agricultural employment, but they're also coming over on H-2A visas and then absconding to go into other industries that are higher paying, such as construction and manufacturing. And some employers in those industries are so desperate for workers that they're increasing wages and paying more, and it's just resulting in a lot more opportunities for workers and a lot more temptation. And then we've even seen things like workers absconding and then coming back in on a different visa the following year under the program and absconding yet again. And so we have kind of serial or repeat offenders on this, and there's not really currently a database for them to be able to know at the border, whether this is somebody who's a serial absconder. The other unusual thing we've been seeing is that groups are leaving together. And what they'll do is, they'll commit to a job. You may have a worker who says, I have some relatives or friends from my town in Mexico, and they want to come over and work. And then they come in on the visa, and the whole crew takes off and leaves. And so it just results in multiple problems. Of course, the biggest issue is you've got a lack of workers that you were expecting, and you don't have enough to get the work done that you were anticipating when you submitted your job order. And then there's also a cost to the employers. You have to pay to get them here. There's administrative cost on the front end to get them processed. And then if they do show up, and some of them are absconding before they even show up to the farm, others are coming and showing up for a week. If they do show up, you're still obligated to pay those front end fees, which are the cost of travel and the first week pay requirements, where you've got to reimburse to make sure that you're meeting the AEWR. And you've got to do this even if you suspect that they're going to abscond at some point. The biggest thing to remember too is to avoid some of the expense that's associated with absconding workers, is to make sure that you're reporting them. This will absolve you of the 48-hour or the 3/4 guarantee for these workers, and return the cost of return travel. You have to report within 48 hours of discovering that the worker has absconded. And so, somebody might abscond on a Saturday and they don't work Sunday, and you don't figure out until they're gone until Monday, then you'd have until Wednesday to report that. And you can find the form on the DOL website to be able to report it, and they'll show you the list on there of everything that you've got, all the information that needs to be included when you report. So the question then is, okay, so what do we do? How do we prevent this from happening, right? So Marty, if you can slide over to the next slide. And unfortunately, there's not a lot that you can do that's really allowed and is not going to get you in trouble. And one of the things that a couple of my clients have tried out this year, and to kind of mixed success, is you can offer bonuses for staying. And it's got to be truly a bonus that's just for staying. And it's, if you stay through a certain time period, then we're going to give you X number of dollars. If you anticipate doing that ahead of time, you want to make sure that that's included in your job order. You want to make sure that it's non-discriminatory. You're not only offering it to a certain group of workers. And you've got to be especially careful that if you're offering it to your H-2A workers, that you've got to offer it to the domestic workers who are engaged in corresponding employment, and all those things we always talk about in terms of, it's only an overlap in duties that can inadvertently create a situation where you're trying to keep some distance between what the H-2A workers are doing and what your domestic workers are doing. And oftentimes it'll be inadvertent that you convert some of those domestic workers into corresponding employment. And then, of course, the other thing is make sure that we're treating the employees right. And a lot of what Marty just talked about in terms of heat issues are important. And then, focus on employee morale, do things that we always try and do to develop that kind of loyalty with respect to if you keep your happy workers and your workers that feel like they're being treated fairly are going to be less likely to leave you hanging in the lurch just for a couple extra dollars an hour or whatever the case may be. And then in terms of taking actions to report employees outside of the USCIS DOL process, we have concerns with that we're going to get into worker trafficking type issues. You can't put employees on blacklist or anything like that. You can't. And so let's just talk about that. That's been dominating the news, especially in Georgia this year due to some big stories. And the idea is not to, growers don't get in trouble with this because they're engaged in human trafficking, right? Most of the time. They get in trouble because they inadvertently do things that fall under, that the government considers to fall under the realm of human trafficking. And one of the biggest issues we've seen with this over the years involves employee immigration documents, right? And a lot of times clients will tell us, hey, well, the workers asked me to keep their documentation for them so that they wouldn't lose them. And so I did. And the government's going to consider that to be evidence of human trafficking because you're limiting their ability to move without their documentation. You also want to make sure that you take a look at your non-work time limitations on employee-free movement. I had a case up in Wisconsin where I had a labor contractor whose idea was, these employees are here to work. And so I'm not allowing them to leave the farm property or the housing unless, we're taking them to the store once a week and whatever. And this can sometimes be in response to things like employees are going out and partying on Sunday nights and then showing up to work Monday morning hungover and unable to work. So, with the intent not to restrict movement, but ultimately it has that effect. You want to make sure that you're evaluating and vetting any farm labor contractors that you work with. There's a misnomer among growers who utilize farm labor contractors that, okay, I'm absolving myself of responsibility. I'm not the employer here. But you really can't just bury your head in the sand with respect to those obligations, because if you knew or should have known, then the government is going to impute that knowledge to you. And that doesn't necessarily mean you, the owner, the farm owner. It can be any knowledge that your managers or supervisors have of anything that may be going on. That's going to be attributed to you as well. And so you want to make sure that not only you're vetting your farm labor contractors, but also that you're making sure that you're monitoring that to make sure that that they're not engaged in any human trafficking type activity. And you want to look for things like, if you hear about employees working at other locations, they may be working way more hours than what they should be based on the job order that was submitted. They may be working on you want to make sure that you know what their housing looks like, that you know that they're getting paid properly, even if you're not making the payments. You want to make sure, and overall, just being aware, and also making sure that your frontline supervisors and managers are aware that if they know of something that's going on, them saying, well, that's not our employee, we don't have to worry about it, is likely not going to fly if that FLC or your farm comes under investigation. You want to make sure that if you have an agreement, that you have an affirmative statement in your FLC agreement that there's no illegal fees being charged. Again, the paper is the starting point. That's your first line of defense. But ultimately, if you have knowledge or suspicion that there's some kind of illegal fee charging going on, then that knowledge is likely going to be attributed to you. So it kind of runs counter to, okay, what can we do in terms of rules and policies to prevent our workers from absconding? But it's a fine line between that and then some activity that could inadvertently, of course, bring you into the realm of human trafficking.
All right, so, and Dusty, I saw your question. So Dusty has a question about whether retention bonuses that Josh talked about are subject to overtime if they have to be included. So it's a great question. It's a complicated question. It's a regular rate question. And the simple answer, because it can be a complicated analysis, the simple answer is yes. A retention bonus is usually going to be included in the regular rate. And so what that means is if they're overtime eligible employees, that means that bonus is spread out over the period it's earned, and you have to figure out how much overtime you would owe on the bonus as well. For non-overtime earning employees, it's not a consideration, but it's a very good question. They changed the regular rate regulations about 4 years ago now, and specifically address that. There are a few opportunities to avoid inclusion in the regular rate. They're A, risky, and B, really hard to thread the needle on. And so, we've done a lot of retention bonuses, both for ag employees or employers and for non-ag employers since COVID started. And the general consensus is it's not worth the risk. Include it in the regular rate, be safe, and don't risk what would be a collective action. Meaning people are going to sue you all together, because if you make that violation for one, you're doing it for everybody. So a couple other quick hit things, and then we'll open it up for questions. This is not new, but it's happening more and more and more. And I used two examples from this year. Was a heat stress call that we got where USDOL wage and hour followed up same day for an investigation. Keep in mind, and the wage investigators don't have to receive a complaint. They can just show up. Same thing with heat stress if you're on the list of covered entities. And then we also earlier this year, and actually I say this year, it was end of last year, had a wage investigation where OSHA came along and started asking questions about COVID and COVID policies and practices that Josh and I actually worked on together. That was, just, it's unfortunate. It's not that you're necessarily doing anything wrong. It's just the cost of having to respond to more and more questions and comply with, somebody who's going to be out on site for as long as they are now staying. It's unfortunate. So be prepared for that, and understand that, look, if you're sharing information with one of these entities, assume it could be shared more broadly than that. And in fact, I've even seen Georgia DOL sharing with federal USDOL, which had never happened. I'd never seen that before until last year. So, your responses to unemployment, your responses to who's the proper employer, things like that are now being shared amongst federal and state agencies, which is different than we've seen before.
Yeah, I've also had a case, a non-ag client, but where they underwent and they were treating a group of employees as independent contractors in Tennessee. and they got audited by the IRS on the independent contractor status of those employees. And about a year and a half later, they got a Department of Labor investigation in Georgia, and the investigator actually told me that they were tipped off by the IRS based on the audit in Tennessee.
Yeah, that kind of stuff is happening more and more. And it's interesting, Josh, that where it happens, sometimes interstate too, where we see, Tennessee, you might have operations in Tennessee and Georgia and North Carolina, and they might tip state to state. So these things are happening pretty frequently. Just real quick on AEWR, there's not any substantial change from when we last did our podcast on the AEWR proposed rule. The 1920 rule that was enjoined last year remains enjoined. A new rule was proposed this year. It is very similar to the rule we've all been looking at for the last 2 or 3 years and been scared of, by the way, for the last 2 or 3 years. The key difference is it removed the freeze on AEWR, which was, of course, the big complaint that was raised out in California that led to the injunction. And it's took away the FLS, the farm labor surveys that were eliminated. It took that part out, so it went back to using FLS for wage surveys. As a quick reminder on what the new AEWR is proposing to do, it's not a final rule yet, it's a proposed rule. It basically gives you these 6 categories where we have the defined AEWR set nationally, by local local wages. If it doesn't fall in one of those 6 codes, then you look at the FLS. If it's not in the FLS, easy for me to say apparently. If it's not in the FLS, you look to this other non-labor wage survey, and it's really problematic. And there were over 100 comments filed to this proposed rule. It's really problematic to look at a non-labor ag labor survey because it includes like truck drivers that might work for a national company where it's just a different job, a very different job. And so we're talking about what looks like a gross inflation on wages if you end up falling in the non-FLS category. The other component is, of course, if you fall into multiple categories, you had to be paid in the highest category you could possibly have fallen into, which led to our huge concerns. And it's really not about what the rule says, it's about what the rule doesn't say, which is, how do you determine this? There was no primary duty analysis. So, and that was the biggest comment that we saw from employers was we need some sort of primary duty analysis to say, well, which category do I fall into? And if I don't know, what happens if it's just de minimis? I'm a traditional, farm labor contractor or farm labor worker, fall under one of those SOC codes, but I also do driving on occasion. And by on occasion, I mean, it was 2 days during the year. Is there a de minimis rule where that doesn't change their category? Or if it wasn't expected, we saw a lot of comments about, well, what happens if there's like a storm and the storm knocks down something and they go and have to help reconstruct fences and buildings just for a day or two in response to the storm to get operations back up and running? Does that change the category they were placed in? And if so, is it just the one person or is it the entire job category as we've had concerns about? And even the entire contract. So we don't have a lot of answers to those. We have a lot of concerns about that. And we're hoping, because these comments have now been through 2 cycles since we had the original 2019-2020 proposed change and then this year's proposed rule. So we're hoping the final rule will address some of this, at least in the commentary before the final rule. So they usually publish about 20 to 30 pages of commentary about the comments before they actually publish the final rule. And if nothing else, I'd love to see that addressed when they publish the final rule. And I do see, Josh, I'm not sure if you can see the question from Beth in the chat, but we'll start with the question that's there, which is, do we expect Georgia farm growers to be really under the microscope because of the negative publicity from the H2A program that the H2A program is receiving right now? What's your thought on that?
Yeah, I would say this. I don't know whether you're going to be under, whether Georgia growers are going to be under additional scrutiny as compared to other states, and especially as compared to other states in the Southeast. I think one, if you're an ag employer, and then two, especially if you are an H2A employer, you are going to be under the microscope more than other people in other industries. And then the other factor being that farm labor contractors are going to be under greater scrutiny, which means if you are using farm labor contractors, you are going to be under additional scrutiny, and there's going to probably be a higher duty than you expect for you to make sure that the workers who are working on your farm are not being mistreated. And so I don't know if there's a geographic component to it. I don't have any reason to believe that would be true. It could be. They will regularly decide that they're going to target a certain geographic area for no reason. And have, we've heard in past years, even before the publicity in Georgia, that, Georgia growers or even Georgia farmers involved in dealing with certain commodity, certain types of growers and certain types of farmers were going to be under additional scrutiny. So, I would, we've been saying this to H2A employers, and you all know this, that if you're in the H2A program, it's not when you will be investigated. It's not if you will be investigated, it's when. And so that's kind of how I would respond to that one.
Yeah. And just to add to that, I don't think it's just if and when, but how many times will you be investigated and reviewed? I have some clients who seems like sort of an annual ritual these days is when USDOL or OSHA shows up and has the exact same questions they had the year before. And it's not necessarily because they found any issues or violations. So it's, my response, I guess, to that is, boy, how frustrating, because they have to call us every time. And I feel bad about that. It's problematic, but it's a target. And so I've definitely seen an increase in the focus and agree with you. I don't think it's Georgia specific, although there may be more questions aimed at Georgia growers related to human trafficking in the next couple of years.
So I do have a few other questions that came in throughout. I guess we'll start at the very top here. So would you recommend that COVID testing be part of a new higher testing protocol, i.e. with drug testing?
So my perspective on that is no. I just don't think you get the value out of it anymore. I think the EEOC is clearly trending in a direction to say don't do it. And I wouldn't even be surprised to have them say, that you shouldn't be testing post-op or pre-hire at some point. So although the current guidance allows for it, it's kind of one of those things where I don't mind a screening question for an employee post-op or pre-hire. But if an employee says that they're not sick and they haven't been around COVID, I don't know that it's really worth any value to go ahead and test them. All that can happen is that you gain information you didn't have. And it's like when Josh and I talk to employers about asking questions during interviews. You don't ask the questions that the answer to is something you don't want to know.
I feel like we could apply that to lots of things in life.
Yeah, that's right.
So here's the next one. I put it in the chat because just in case it's easier to read and think through. Assuming the new OSHA heat rules are challenged, how and when will that impact those of us working outdoors in the meantime?
Well, I think the answer to that is it's already impacting us because OSHA is using general duty to enforce some standard that no one knows. That's what's the most frustrating. I actually think seeing the rules would be particularly helpful, because at least you'd be able to know, well, if I comply with this set of obligations, I'm safe and I won't be cited. But instead, it's sort of this malleable standard that no one is entirely sure what OSHA's expectations are. And they actually differ. What's fascinating is they actually differ geographically. So the Dallas office has been really aggressive with the heat standard and their application of the general duty clause. And Travis was telling me about some crazy citations that have been issued. So what I think we need to be focused on is, yes, the challenges are going to be important to trying to strike down their ability to regulate it. But I also think they're somewhat welcome in that they at least give you notice of, if I do these things, I'm safe.
So Dusty just put in the chat that he just got a call 5 minutes ago that one of his farmers was getting a wage and hour investigation today in Southeast Georgia. He's an H-2A employer, has cotton and peanuts. I'm going to emphasize this. So they're out there.
They are out there.
Yes.
That's for sure.
Yes. So, okay. Next question. Should growers keep employees from doing anything outside of the job description? In other words, should we not allow them to move a piece of equipment and keep them strictly to the defined rules, which would be very difficult?
Yeah. What's your perspective on that, Josh?
Yeah, I mean, there's one of the things Marty talked about with the new proposal was there was no de minimis. There was no de minimis statement statement in the new rule, and certainly, somebody moving a piece of equipment outside of the job order one time is not likely going to put the other people who do that in corresponding employment, right? I mean, that's the main reason you want to do that, is so that you're maintaining one, the exemption if you're applying that, and two, that you're avoiding putting domestic workers in corresponding employment and subject to the requirements of the job order. So, well, ideally you want to minimize the overlap. Realistically speaking, a one-time thing is not gonna get you in trouble, but the tendency is that one-time thing turns into a more than one-time thing, and then that's where you experience increased risk.
Yeah, and the other concern, and this is something we can't really expect or give any reasonable anticipated result on, is if the employee is being educated by any number of different potential individuals or entities to call and complain if they're working outside of their job description even once, whether it's a lawyer or an advocacy group or whatever that gets a hold of these individuals, that's a whole different scenario. And you may be getting investigated as a result of somebody doing it once, even though that shouldn't be. I agree with Josh. That's very unlikely to lead to a violation being found here of the AEWR rules. But if they complain and then they say, oh, this is happening all the time. So I think it's just something we're going to have to wait and see and be careful about.
It seems like we're definitely at a place where we need to look at the regulation and make sure whatever regulation it is that we're doing that, but we also need to make sure that we're paying more attention. I think with the USDOL investigation that's going on right now, it's really shown us that more than the regulation, we really need to be thinking of more than just a regulation and paying a lot more attention to that. So here's another question. So much push for immigration reform at the congressional level this year. Do you see any legislation moving forward?
Marty and I both have blank looks on our faces on that one. Maybe Cynthia.
I mean, I think my reaction to that is I think just the current situation, there's very little legislation getting passed, period. So let alone something as big of a hot button issue as immigration reform. So do I think it'll continue to be a big topic? Yes. But do I see any meaningful change through legislation being passed? Probably not. At least not through the current the Congress as we see it currently. Let's wait and see what happens in November.
Gotcha. So I don't have any other questions. We have about 4 minutes left. Are there any other questions from the audience? Definitely don't want to drag this out, but it's a great opportunity to be able to ask very real questions to two very knowledgeable ag attorneys. So I have put information, ways to get in touch with Marty and Josh. If y'all have any additional questions, this is the web link to their individual profiles on the Fisher Phillips website. So there's contact information, phone numbers, emails, and all that kind of thing. So feel free to reach out to them if you have ongoing questions or in-depth things that you need to talk through. They're fantastic ways or fantastic people to be in touch with and to talk through things with. In addition, a couple of things that we've got coming up. We've got the Georgia Ag Labor Relations Forum coming up this November, the 9th and 10th in Tifton, Georgia. It's actually at a new location at AVAC's Georgia Museum of Agriculture. That used to be the old Agorama. So registration is definitely now open. And that website is right there, georgiaaglaborforum.com. Also coming up very soon is the Southeast Regional Fruit and Vegetable Conference, which is January the 5th through the 8th, 2023. It's in Savannah, Georgia. Registration for that is also open. I bring both of those up to say, if this is the type of thing that you need more information about, you need more in-depth discussion on, or if you just need to stay on top of some of these things, these are two very good places to go to find out more information about upcoming ag labor laws, issues, what's going on with OSHA and heat regulations and things of that nature. So with that, I just want to thank Marty and Josh again of Fisher Phillips. Thank you for sharing your insights. Thank you for sharing your expertise and your time during this webinar. Any last words from you guys?
No, everybody be safe.
All right.
Thank you for having us.
Thank you. I want to say thank you to all of you for joining us on this discussion, this webinar. Feel free to contact us at the Georgia Fruit and Vegetable Growers Association if you have further questions about this. We may not have the answer, but we know those that do. So thank you again. And with that, we will conclude this webinar. Thank you.